Hi there, this is Jonathan Ginsberg, and I want to talk to you today about potential issues that a creditor may bring up in your Chapter 7 case. And specifically, I'm talking about creditor objections to your Chapter 7. First, I want to reassure you, really unlikely. Very, very rarely do I see creditor objections in Chapter 7 cases, mainly because it's not worth the money. You're filing bankruptcy, you don't have any money, obviously, presumably so at least. So for a creditor to hire an attorney to file an objection, the stakes have to be pretty high, and there needs to be some conduct that really warrants that. And that's usually not the case in Chapter 7, most consumer Chapter 7 cases. But there are three situations that we might find where a creditor says, wait a minute, we think that the debt to us, to our particular company, should not be dischargeable. And that's a specific type of objection, a non-dischargeability objection. One would be a situation where you incurred debt without a, quote, reasonable expectation of repayment. That's typically in the credit card area, where you use your credit card and you've already sort of become insolvent, you're out of work, you've taken a big pay cut, but you're still spending money like you had the capacity to make payments. That would be one basis for a creditor to object. Or you took out a new credit line, that's another situation. A second situation would be where you lied on the credit application. You said that you were making $75,000 a year when in fact you're really only making $45,000 a year. And the evidence, the documents will show that you were only making $45,000, and so that you misrepresented on your application. The third type of objection that I see, again, very rare, but it does happen, is personal. And that's when maybe you had a business partner, a friend, somebody that you had some financial dealings with, it blew up, and now you're trying to file bankruptcy to make it go away, and your friend or your former friend who's got money, unfortunately, basically doesn't really care about the money but just wants to mess with you and screw you up. Those are really hard, by the way, but that does happen sometime. And of course, if that's the situation, make sure that your lawyer knows about it. I got involved in one of those a few years ago. It's probably still going on. It's just complete disaster, and it's really not about the money. It's about inflicting pain. And again, you can't really settle those because it's not about money. So if you have an objection, objection to dischargeability of debt objection, you can litigate it. That gets real expensive, not a great option. Second thing is settle it. That's what we do most of the time. When we work out a deal, we pay some percentage. Sometimes it's 100%, sometimes 50%, sometimes 10%. But basically, we will negotiate some sort of a deal. A lot of times it involves payments over time, which gives you 6 months, a year, maybe even longer to make payments. Again, those are typically what we try to do. Litigation, the least desirable, but if it's a personal type of thing, that may be required. We have to deal with that. There is a second type of objection, and this is called an objection to dischargeability, a lot more serious, and that's when a creditor says, there's so much fraud here, we think that the entire discharge, the entire Chapter 7 ought to be just thrown out. It's not just about us, it's about the whole thing. And that would be a case where there's just misrepresentation about assets, you're hiding assets, there's all kind of fraud, there's been just fraud for years and years, things like that. Those cases you got to litigate them, because you can't settle a partial fraud. Either there's fraud or there's not. And those are ones that you really want to make sure your lawyer knows about. So if you know there's been some funny business in your past, rather than file bankruptcy and kind of hope nobody finds out, trust me, they're going to find out. So it's better to talk to your lawyer, and sometimes my advice will be don't file bankruptcy at all. All you're doing is you're just waking a sleeping dog. It's much better to more subtly approach the aggrieved parties and try to work something out, or just lay low and hope that nothing will happen, and people will kind of grow weary of it over time. But if you know that there's a problem there, whether it's with a particular creditor or overall, make sure you talk to your lawyer about it. Let us know. We can really help you and give you proper advice. But if you file the case and then after we get an objection, oh yeah, didn't I mention that? Well, no, you didn't. Not a good thing. So anyway, I hope this has been helpful. I hope you understand, again, that we're on your side as your attorney, that we want to make sure that anything that we have to deal with negatively, we can do so, and that we're there for you to help get the most relief you possibly can get from your Chapter 7 case. My name is Jonathan Ginsberg. Any questions about this or any other consumer bankruptcy matter, please feel free to let me know.